I don't think so. You guys are all lawyers. You can talk for 2 minutes.
The problem is always up to water.
Probably what we want to do is somehow draw lots. Okay.
It's not bad for your party.
Okay, so this will be open, and then every question we're going to rotate, so it's a different order. Thank you. Okay. So you got to tell Chase like
Write down your name.
Ooh.
Right?
Three. So it's going to be David, you, and then me. You ready?
You saving a seat? Get out with my fingers. All right, welcome everybody. Thank you for being here. Let's get started. Have your attention, please. Thank you. All right, welcome to the debate for the candidates for Utah County Attorney. So my name is Nelson Abbott. I'll be a co-moderator at this debate. And our other co-moderator is right here, Chase Atchison. So what we're going to do first is we're going to, first we'll start with a pledge and a prayer. And some of you may have been handed out cards to put down questions that you wanted to ask. After the pledge and the prayer, I've got some just blank 3x5 cards. If you have other questions that you think we should be asking, I'm going to hand those out while Chase is talking, and you can write questions down here, and then we'll look at those, and we may or may not ask them at the end of the day. But anyways, so our prayer today will be offered by Greg Adams. He's the precinct chair, PG 314.
Our Father in heaven, we are grateful to be gathered today as delegates, as fellow citizens, and as children of Thee. Father, we're so grateful to live in a nation where we have the freedoms to gather as we do, to vet out candidates that we best and hope feel will uphold the standards that this nation was founded on. Father, help us to decide on candidates that will consider thee before making policies and decisions that affect our lives. Father, we're, again, grateful. We ask that those that are here tonight, that they will be able to be articulate and clear, and that the questions we ask will be able to help us understand who will be the best attorney for this county. Again, Father, we thank thee. We say this in Jesus Christ. Amen.
Amen.
Okay, and then our pledge tonight will be offered by Bob Bates, and I just got to say something. He is a World War II veteran, which is amazing. Sadly, there's not a lot of them left, so it's great to have him here with us. When I walked in today, he opened the door and held it open for me, so he's still serving people after all these years, which is fantastic. So,
If you all stand, please. Place your hand over your heart and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. God bless us.
Thank you so much, Bob and Greg. My name is Chase Atchison. Again, I'm here co-hosting with Nelson Abbott. We are so excited to be here with you this evening. This is an excellent opportunity to learn about the candidates who will be serving us as Utah County residents. First, we'd like to thank doTERRA for letting us use this lovely auditorium. It is a spectacular place. We are so happy. We also would like to thank Craig Thorne. Craig, where are you? He is still serving. Well, when Craig comes in, if he comes in the next minute, we'll give him a round of applause. But he is a Superman. He is the closest thing to a superhero that this county has. Craig has been serving so long, and he gives of himself so easily. The nearest emergency exits are behind you and to this side. Should there be an emergency, please stand up and exit in an orderly and calm manner, as calm as we can be if the building's on fire. And also restrooms, the closest restrooms are out that door, and you take a left, and I believe it's right between Kevin Stratton and Rod Mann's tables, so looks like they cornered a good spot in the market, as well as those are water fountains. And as we proceed, I ask that you hold your applause until the very end of this debate. We want to make sure that there are no major disturbances. As you can tell, our sound system is a little jumpy. Hopefully we'll be able to make it work. And as you see here, Nelson is passing out cards. You may also have passed put your questions on these cards. If you have not had an opportunity to write down a question, please raise your hand, and Nelson will try and get it to you. Okay. All right, let's talk about our format for this evening. Our candidates have drawn lots for their personal introductions, which will last 2 minutes. We have our timer here. What's your name again, timer? Seth. Seth is going to raise our cards. One is a 15-second warning, and the other is a time warning. If you don't stop, he will shout, stop. We've told him to be forceful. We've told him to lay down the law, given this is a county attorney debate, questions will either be 30 seconds long. In order, responses to those questions will be either 30 seconds or 1 minute. And Seth here will let us, he'll keep us on track. If one of you is mentioned directly in a response given by one of your competitors, you will have a 30-second rebuttal. Even if they don't say your name, but they're obviously talking about you, you'll get a rebuttal. So, following all the questions, we will have a 2-minute each closing statement. Then you can apply. Okay. Nelson, you want to kick us off?
Sure. Well, yeah. So let's start with the opening statements, obviously. So I think we drew cards.
Yeah,
So
first
see who
is
would go
David.
first. Yes, David Leavitt first, and then it was Jeff Gray, and then Adam Pomeroy. So.
Good evening. Thomas Jefferson said that a trial by jury is the only mechanism whereby the people can keep a government within the bounds of its own constitution. John Adams said that representative government and the trial by jury are the heart and lungs of our liberty. That without each of them, there is no mechanism whereby the people can avoid being worked like cattle, ridden like horses, and fed and clothed like swine and hounds. Why is that? For one reason. If you get rid of the checks and the balances in government, where the people don't decide the guilt or innocence of fellow citizens, then we live in a police state. We erode two important checks and balances. Now, those checks and balances existed in government until the Civil War, until we began to introduce something in the Civil War called a plea bargain. Plea bargains were a horrible thing back then, and everyone knew that they were a corrupt system. But they began to get popularity and grow because they were easier for everyone in the system. By the time we got to 1969, plea bargains still had not been determined to be legal, but we were plea bargaining 75% of our cases. Finally, the Supreme Court legalized plea bargains, and then it exploded. Prosecutors advocated their role in being a check against the police, on the one hand, and they usurped from the people the role of the jury at an exponential rate. By the year 2019, prosecutors were giving plea bargains in over 99% of cases in America and in Utah County, which means that 99% of the time, the government doesn't prove its case. That's why I'm running.
Before you begin, we have these questions that are going around. If you have not had your question picked up, please raise your hand and Nelson will get to it.
My name is, Jeff Gray, and I'm going to tell you a little bit about myself. So I grew up in Mapleton, Utah. My wife and I, we grow up in Mapleton, or we live in Mapleton. We've grown up now. So we live in Mapleton, Utah. And this county is very dear to me. I've been a prosecutor for 31 years. I started here in northern Utah County, small law firm, and we represented the northern Utah County cities. And that's where I got my start in prosecution. Now these cities, Alpine in particular, and Highland, they're a lot bigger than when I started. So I prosecuted misdemeanor crimes. I did that for 3 years, DUIs, domestic violence. And then I went to the Salt Lake City Prosecutor's Office. And at the Salt Lake City Prosecutor's Office, I continued to do the same, prosecuting misdemeanor crimes like domestic violence, DUI, and more that fortunately I don't think we have yet. And then I went to the Attorney General's office, and I prosecuted for 3 years as a trial prosecutor, prosecuting white-collar crime. And the last 24 years, I've been with the Criminal Appeals Division. And I've handled hundreds of cases in that. And I was actually thinking about retiring. Okay, I've been out there for 31 years. And I thought,
But the more I heard about the current policies in the current office, I knew that I needed to run and make a difference. I will prosecute. That's what we need to do, is prosecute crime. That is the job of the county attorney.
Good evening. My name is Adam Pomeroy, and I'm running for Utah County Attorney. I'm a current Deputy County Attorney, and I'm running for this office because from within, I see the need for change. I feel a keen sense of urgency to change the mistaken direction of our office. We are not doing right by victims. We are not doing right by law enforcement, and we are not doing right by offenders. And that is affecting you, your families, and our community. Well, our questions tonight are going to get into that, so I did want to take a moment to introduce myself to you. I'm an honors graduate of BYU Law School. After law school, I did a constitutional litigation fellowship at a place called Pacific Legal Foundation, formed by members of then Governor Rader's administration to protect individual rights from government overreach. And that's what I did. It was a wonderful experience getting to engage in lawsuits when the government has overstepped. I also wrote a law review article there that was cited last year by Justice Thomas of the United States Supreme Court. But after that fellowship ended, we had a decision to make. My wife and I said, this is where we want to raise our growing family. Utah County, her childhood home. So we came back. I started my own law firm doing criminal defense, where my main goal was to defend people, but make sure that their constitutional rights were vigorously defended. And then one day in court, the former chief deputy of this office said, Adam, there's an opening. Would you please apply? And I did. A few weeks later, I was sworn in, and I've been here ever since, and I have loved every minute of it. I love being a prosecutor. I've done almost everything you can do prosecutorial-wise in the office. I've been on the general felonies. I've done juvenile court, misdemeanor court, special victims unit, the major crimes assignment, which is the task force dedicated to narcotics and gangs. I've been on the screening team. And these experiences have taught me that we have a lot of work to do to make our system better. But we make it better by holding people accountable. I'm the only candidate with my unique set of experience, and I'm the only candidate with the current in-place relationships, perspective, and understanding to get the job done. Thank you.
Okay, now we're going to move into kind of even more rapid fire. I know that was pretty quick. 2 minutes isn't a lot of time to introduce yourself. But these are going to be really rapid fire because they're going to be 1 minute each, and we're going to have the candidates, at least for these first ones, we'll have each candidate answer. So the first question is, what is the proper role of an elected county attorney? And the order that we're going to go in is going to be Adam Pomeroy, David Leavitt, and then Jeff Gray.
The proper role of the elected county attorney is to serve the people of the county that elected him. The proper role is to vigorously prosecute crimes, to work with law enforcement for your benefit, and to effectively manage the office. Thank you.
Can I have this time?
The county attorney has two roles. Now, I have been a county attorney for 11 years. I've been a county attorney in Utah County for 4 years. I was a county attorney in a rural county for 8 years. As the elected prosecutor, you are the chief law enforcement official for the county on all criminal matters, and you are also the civil advisor to the county commission, the county sheriff, assessor, auditor, treasurer, clerk, recorder, etc. And so it requires balance. You have to be able to have not only prosecution understanding, but you also have to be able to have civil experience to be able to advise all of county government. Now, if you distill what I believe the responsibilities of the county attorney's office is, number one, the county attorney's office is to uphold your oath. The oath you swear is to uphold and defend the Constitution of the United States. It's not necessarily to work for the police, it's to work with the police, but to support the Constitution, and then to support the Constitution in representing the civil people of the country.
David is right. There's two roles. First, prosecution and provide sound legal advice and representation to our county and county agencies. 80% of what the county attorney's office does is the prosecution side. And quite frankly, that's what's not happening right now. We're soft on crime, and we cannot be soft on crime. The proper role of the county attorney is to prosecute crime. Number one, prosecute crime. And what the evidence supports. It has to be what the evidence supports, not some notion of fairness as to less charges. So that's number one. Number two is to support and work with law enforcement. We are on the same team. We need to work together and provide training to law enforcement so they do their jobs and to uphold the law. And we'll talk about that later. But also to keep our communities safe.
Nelson, I think I get a rebuttal. I get 30 seconds on soft on crime.
I think that's right.
I've prosecuted as a county attorney, statistically speaking, I've filed more sex crimes cases than my predecessors. That's a fact, and I'll send you all a mailer that shows the numbers. We've prosecuted homicide cases, sex abuse cases. We put people in jail who are violent and dangerous. To say that I'm soft on crime is a simple allegation that can't be supported by actual numerical facts, and it's just not true. The violent and dangerous, they go to prison, and we put them there. But those that are not violent, we have a different solution for them. That's not soft on crime, that's just smart.
Thank you very much. I meant to do this at the beginning, but those of you who are Utah County Republican delegates, please raise your hand. So these guys are going to be choosing between you three, so keep that in mind. Thank you so much. I appreciate the participation. All right. Now, I am not an attorney. I hope most of you aren't attorneys, but it's part of an attorney's, especially the county attorney's, responsibility to explain complex ideas in a way that we, the electorate, understand. So this is our question. How do you plan to reduce felon and misdemeanor recidivism in the county? The order that we're going to be answering that question is going to be Jeff, Adam, David.
We have to start by holding them accountable. That's how you reduce recidivism. You don't undercharge, but you hold them accountable. You don't do a pre-filing diversion program where they're never charged, all right, and then hope that they do well. You require accountability, all right? For the drug cases, the users, you get a guilty plea. You get a guilty plea, and then if they can hold the guilty plea in abeyance, all right, ask the court to do that. And then from there, if they comply, if they go through drug rehab and so forth, and stay clean, then it's dismissed. If not, you go straight to sentencing. We charge what the evidence supports, and that is not happening. There is no charging with respect to law enforcement if they're assaulted or interfering with arrest. I've talked to law enforcement, that's not happening. If you want to reduce recidivism, you hold the criminals accountable.
You admit it, you fix it, and you move on with life. So I teach my kids the principle that works for everyone. And Jeff is right, we are not holding people accountable in this county right now. We are consistently undercharging and refusing to enhance repeat offenders. You've seen the news article, felony death filings are down by half. That's what's going on. To hold people accountable, you must start by figuring out the crime that they did and charge appropriately. But then you individualize. You have to have the wisdom from being on the ground and understanding every program out there available and using the ones that help an individual not recidivate. You find the one that helps them get over their issues, whether that's drugs or mental health or just making stupid life choices. There are incredible programs out there that I know about because I'm doing this job and I'm in the courtroom every day. So once you found it and they've either not been amenable to fixing their problem and you have to send them to jail, or they fix their problem, you help both groups re-enter the community and move on with their lives. That will benefit all of us. Thank you.
Now, David gets 90 seconds because he specifically called out.
Twice, don't I get 120?
No.
It would be one thing, what they're talking about academically makes sense, right? Everyone should be held accountable. Swift sanctions very quickly. The problem with the system that the bureaucrats have designed is that it takes a year from charging to pleading to get a plea bargain, and then all the hope of a swift sanction is gone. They never learn their lesson, and the courts don't hold them accountable. Roughly 60 to 65% of criminals who violate their probation have no consequences given to them by the judge. So their method is to charge more. Let's give them 10, 15, 20 different criminal charges, and nothing ever happens to them, ever. What my plan is a pre-filing diversion program. It gives a swift sentence, a swift sanction on the front end. You commit an offense on Friday, we're at your front step on Tuesday, we're giving you a swift sentence that week. And if you complete it and do so faithfully, then we don't make you a criminal. So that when you are later in life, you can get a job, you can get a house, you can have a life. It's about understanding that our punishments should be to change behavior and should be redemptive in nature, not punitive in nature. Because most of these people are nonviolent people, and that's what I'm doing. And by the way, all three members of the county commission agreed with this, funded $5 million for this program because they also agree with this program.
I believe we both get rebuttal. So 30 seconds.
All right. I mean, he talked about sentence. There is no sentence. There is no charge in his pre-filing diversion program. There is no accountability. He talks about accountability. There is no accountability because there's no guilty plea. I will hold criminals accountable, and it's quite frankly, when they take responsibility by pleading guilty, that's the first step to reform, not by shoving it off and you're not facing anything.
Do you want to know the truth about the problem with the pre-filing diversion program? No judge, no defense attorney. You get a letter in the mail that says, I, as the county attorney, demand that you do this, or I prosecute you. We talk about checks and balances. Where are the checks and balances in that system? I'm the only one up here talking about being smart.
Please hold your applause for the end of the debate.
And we do need to be smart, and we do need to figure out who needs the hammer, but who needs the hand up. Thank you.
Again, please hold your applause for the end of the debate. All right. Here is a hot button topic. Please hold your applause for the end of the debate. So, yesterday, Governor Spencer Cox signed a bill into law, HB 257, which places limits on pre-filing diversion programs. This bill was sponsored by 2 Republican-elected Utah County representatives. So, what is your position on this pre-filing diversion, the limitations on the pre-filing diversion programs? The order is going to be...
What kind of limitations does the bill provide?
I will let our gentlemen here just explain and put forward their positions. Our order is going to be David, Adam, Jeff.
HB 257 is emblematic of what's going on here. I am trying to restore the system the founders created, and the bureaucrats are trying to stop me. The bureaucrats want to have a cattle car experience of the criminal justice system where everyone, they want to charge, they want to convict, but they don't want to prove it, right? Do you think we ought to prove the allegations we make? Because the system that these guys want to do You simply can't do it. That's why we never proved guilt. HB 257 was an effort on the part of former prosecutors from my office who actually believed that the government should punish without proving. Now, I can live with HB 257 because I worked with the legislatures to pare it down so that it does nothing to harm my program. So I'm fine with HB 257.
No one said no trials. No one said no proof. I'm not an advocate for that. I'm an advocate for doing it within the system. Pre-felon diversion is wrong. Post-felon diversion, we can have a conversation about that. Because then we ensure that people's rights are being respected with a defense attorney advocating for them and a judge checking us. I believe there is a role in our system for helping people. I believe there is a role for helping victims and offenders. But you cannot help them if you do not charge them. Now, regarding limitations, I think limitations are good. Limitations are great on prosecutors. You'll talk to your legislatures about why they put those limitations in place, but I suspect the answer will be is because they don't agree with what's been happening in the Utah County Attorney's Office.
I wholeheartedly support House Bill 257. The legislature has decided what the level of crime is, all right, whether it's a felony or a misdemeanor or whatever. And what Mr. Leavitt has been doing is been taking felonies and reducing them to Class B misdemeanors so that they're now in justice court. So now they're facing less punishment than they otherwise would have if he would have filed as a felony as he should have. We need to charge what the evidence supports, period. And this notion that we don't have to prove it, of course we have to prove it. We have to prove every case. Everybody deserves a trial, if they want one. We have to prove it. Nobody's being denied. The only thing that's happening at this stage with this reduction of charges is the county attorney deciding that I don't agree with what the legislature decided on the penalty.
30-second rebuttal.
So you shoplift 3 times, that becomes a felony. Now, every time you shoplift, you can get 6 months in jail, which I wholeheartedly agree. Let's put him in jail for 6 months. We get that on a Class B misdemeanor. The problem is judges won't put you in jail for 6 months on anything for shoplifting. And so these guys say, let's make them felons every time they steal a bag of potato chips. Well, you know what? That's just bad policy. Because you make someone a felon, they're never going to get a job, they're never going to be able to have a place to live in the future, and it affects their entire life. What I'm proposing is let's just punish people for what they do. Let's give them 6 months in jail, but do it as a misdemeanor, not as a felony for something as stupid as a bag of chips.
Who gets the first rebuttal?
We got it.
On that one.
Give them 15 seconds each. How about that?
Okay, your names were not mentioned.
Nobody, that's a flat lie. A bag of chips for a felony, that's not the law. That's a flat out
Hold your applause to the end of the debate.
It's not just a bag of potato chips. It's tools from your garage. It's equipment from Home Depot. It is everything and anything going on in our communities of theft that is not being enhanced, including car theft. It is foolish to say, just put them in jail for 6 months, that will solve the problem. That is not smart. We need to be smart.
All right, so I've got 3 audience questions. I'm going to read all 3, and then I'm going to ask you to answer these kind of combined, because I think they all touch on each other, okay? So the first question, it's kind of long, but here we go. If Congress passes a law which is unconstitutional, but its nullity has not been formally acknowledged by a federal court, such as the U.S. Supreme Court, do you have a duty to enforce that law through prosecuting an alleged defendant, or a duty to ignore and thereby nullify that law? So that's the first question, okay? Second one, which kind of, in my mind at least, related, says, there was a college student that ran a party for kids in 2020 during the height of the COVID panic. Would you pursue charges against the event organizer? Okay. And then the last one is, what determines your priority in prosecuting cases? So I guess the reason I see those as being related is the question being, what is your philosophy in determining what cases get prosecuted and what cases don't get prosecuted? And our order will be Adam Pomeroy, Jeff, and then David Leavitt.
So that was the unconstitutional question, the late party question, and the philosophy question.
Yes, they're
All as
all
one.
combined into one. So I'm
That's
just
like the
trying
rest
to
of the debate right there, Nelson.
maybe it's unrealistic to answer in 1 minute, but I'm hoping we can just kind of get your charging philosophies, if I can.
Sorry, say that again.
I'm just trying to get your charging philosophy.
Charging philosophy. Sorry, thanks for explaining.
That's wrong.
Keep on going. Keep on going. Charging philosophy. Look, my main philosophy that drives everything I do with criminal justice is to respect the individual rights and dignity of people and their moral agency, both for victims and for offenders and for everyone else in the community. So we need to make wise charging decisions that protect individual rights to life, liberty, and property. And we have a legislature who has told us how they want that done. So the first thing we do is we figure out when we get a police report, have they violated the law? If they violated the law, we figure out which law they violated. And then we look at that person as an individual to try to determine the best we can, and it's a hard job, to figure out whether any individualized adjustment needs to be made. And it's almost always going to be on the back end during sentencing, to figure out how we can help this person have accountability by admitting it, but then also how we can have this person fix it so they can move on, thereby benefiting the entire community and not having recidivism. Thank you.
Lake party. Lake party.
Well,
Come on now.
Nelson kind of,
All right,
what do you want to do
give,
about that?
give me an extra 30 seconds and we'll give everybody 90. How about it?
I don't believe in mandates. I just do not believe in mandates. I will advise the commission in my civil capacity to not implement a mask mandate. I would hope the sheriff would not enforce it, and I don't believe he would. But again, if we get a case, there's something going on there, and we have to look at it to figure out what's going on. It's probably going to be a criminal trespass or an assault. And we'll look for the real harm, not you wearing a mask. Thank you.
Next, yeah,
I will charge what the evidence supports, including enhancements. And I don't have this test of whether or not, okay, maybe this person, because of whatever circumstance, I'm not going to charge so many counts. We'll get to that after we charge. And after we've had the opportunity to actually talk to victims after all the charges have been filed, and then we'll talk. Okay, but it doesn't happen at the charging stage. At the charging stage, then you have the prosecutor making decisions without talking to victims and everything else. We need to charge what the evidence supports. And I will charge, including enhancements. And let's talk about the death penalty. I will pursue the death penalty in all appropriate cases. When the county attorney takes an oath, okay, to uphold the law, the state of Utah has determined and seen fit to have the death penalty. He violates that oath when he says that he will not pursue the death penalty in any case. That is violating the oath. We've talked about that. I will uphold the law. Now, I don't remember.
throw you out, whoever you are.
Okay, how much, did you take
20 seconds.
On
20 seconds.
mask mandates?
Lake party.
Don't you charge him in the lake party during COVID? Or not?
Oh, okay, the party. First of all, it wasn't a crime. It was never a crime. All right, Utah County, the commission looked at that. It was never a crime. Of course, I'm not going to charge it. I am against mask mandates.
All right, and then David, I think David was referred to specifically, so we'll give you 2 minutes. 2 minutes. 2 minutes.
my charging philosophy. The violent and the dangerous need to go to prison. I prosecute the violent and the dangerous. And let's talk about the death penalty. I'm the only county attorney in 40 years to pursue the death penalty. I charged it. I pursued it. I spent $4 million of your money on a sentence that will never be carried out. And at the same time I did that, I was neglecting 17 other homicides, 235 sex cases, for a symbolic victory on a death sentence that will never be carried out. To me, you want to have an academic conversation on the death penalty? Let's have it, because I've charged it. Despite, nobody else here has done that. I have. But in a practical reality, life is different. Because I have 235 other victims to deal with and 17 other dead people to care for. And I'm spending your money for a sentence that will never be carried out. That is the ultimate bridge to nowhere. Now, I agree there are people that should die for their crimes, but it's not happening in a for any practical reason. And I have to run an office on the ground and take care of everybody. That's my charging philosophy. Charge the violent, the dangerous, put them in prison. The nonviolent, they're coming back to live among us. They need our help. And that's what I offer. That's what I'm doing. Thank you.
Make party. Make party.
How much time do I get?
5 seconds.
I'm not answering your question in 5 seconds. You're making me 30, I'll answer it.
All right. So,
The time has expired.
all right, we're trying to keep it fair. So, it's kind of a little arbitrary, I get it, because we're given time, but if we start expanding, we'll end up like the presidential debate where you can filibuster the most, so. All right. So, next question. Let's see. So this is, again, I'm going to combine 2 audience questions. Both dealing with the relationship between the county attorney's office and law enforcement. So the first question was, please describe your relationship with the Utah County Attorney or Sheriff's Office and other law enforcement agencies within Utah County. So obviously that one's directed to the city and county attorney. I want to make it a little bit broader. And so the second question is, should the county attorney provide checks and balances on the county sheriff's department? So the question I guess I would pose is, what is the proper role or relationship between the county attorney's office and law enforcement? Okay, so we'll go a minute each, and the order will be Jeff Graves, David Leavitt, and Adam Pomeroy.
Law enforcement and the prosecutors, we're on the same team. Okay, there's not supposed to be a tension between the 2 offices. We're on the same team. Law enforcement officers catch the bad guys, and we prosecute them. Now, one of the important things about that is we need to provide training to law enforcement. I've talked to Sheriff Smith. I've talked to other police chiefs. That training is not happening. That training is not happening. How can we expect law enforcement to do the job right when we're not teaching them and training them in the law? I'm the Search and Seizure Section Director for the Utah Attorney General's Office. I train officers regularly on what they can and cannot do. And one great thing about that is I also learn. I'm not on the front lines, all right? I'm not on the front lines, and the only way that I'm gonna understand that is if I'm talking to law enforcement. I learn as much from them as they do from me.
David.
1 month into office, not far from here in American Fork, a member of the sheriff's office, 3 members of the sheriff's office had a handcuffed man on his stomach and were beating beating him on videotape. It's on
Ladies
you-
and gentlemen,
it's-
do not say
It's on
that.
YouTube.
Don't do that.
You can see it. 3 days before that, one of those same deputies stopped an individual, took the barrel of his rifle and jammed it into the forehead of the person he had stopped, causing a gash on his forehead. And then a member of the sheriff's office took $2,500 of task force drug money and paid him off. And when the sheriff came to me and insisted that I should not investigate that, I thought that relationship is just not going to happen, because I am a check against the sheriff. When they do things wrong, I'll work with the police when they do things right, but I'm a check on them every time they do things wrong, and I always will be.
So much there, right? You know how you provide a proper check on the police? You earn their trust and respect. And I've done that every day for the last 7 years, earning the trust and respect of your local officers, speaking to your chiefs and your sheriffs. I've trained with officers. I've done trainings for them, and I've done their trainings. I did their Hell Week for SWAT. I've done their DUI A-Ride program. I've gone to a checkpoint. And I do that so I can understand them. But then we have to train them. I agree with that. We have to get out there and train them. And it's by working together that they see us and we see them, and we learn to trust. And then, based off that trust, we can have rational conversations to air differences, to talk about where we each can do better. When you can't even sit in the room anymore with your sheriff and your chiefs, that's a failure of leadership. That is not how we properly deal with our relationship with law enforcement. Sorry, what's that time card? Okay, thank you.
We'll give Mr. Leavitt 30 seconds.
Folks, I don't have any problem working myself with police officers, but I'm holding them accountable, and they don't like that. I will always hold the police accountable when they do things wrong, and I'll work with them when they do things right. That's my job.
All right, our next question. As we know, the Special Victims Unit was disbanded. The question is a general question. What is your philosophy on having a Special Victims Unit in the County Attorney's Office? Oh, yeah, excuse me. David, Jeff, Adam.
How much time do we have?
This is a minimum.
I got rid of Special Victims Unit because they weren't prosecuting the cases as they should be prosecuted, frankly. I only have 60 seconds. So I'll just cut to the chase. What I did was I added 3 more prosecutors from the 6 in the team to 9. I put 1 prosecutor that's sex crime trained in each courtroom, so that every courtroom has a sex crime trained prosecutor. And then I sent more prosecutors to specialized training. As things sit in my office today, 19 of my felony trial prosecutors have specialized training in sex crimes prosecution. If you look at the numbers, my office has prosecuted more sex crimes than my predecessor, both by percentage of cases coming in and by sheer numbers. Just because the bureaucratic way of doing it is to say we're going to have this Special Victims Unit doesn't mean it's the only way it can be done. And we're demonstrating that we can do it better.
There is no focus under the current administration on sex crimes, because we have no Special Victims Unit. We need a Special Victims Unit with expert attorneys that have the experience and training to prosecute these cases, and also work as a unit with the detectives that are investigating those cases. That's not happening, and there's been mistakes happening. And as far as the focus on sex crimes, we have a case where child sex abuse, this happened, this is in the news. Child sex abuse happened, And the current administration decided not to pursue the child sex abuse because the offender was no longer in the home. Okay, that is ridiculous. The offender should be punished, number one. And number two, the offender can reoffend again. We don't not prosecute simply because the offender is outside the home. And in many cases, they're not even charging enhancements.
I work with victims almost every day. I was on the Special Victims Unit when it got disbanded, and it was a mistake. It is national best practice for a reason, because the training and expertise required to deal with those specialized cases cannot easily be spread around an entire office. And what happened when that unit was disbanded is what Jeff Gray just told you about cases not being charged appropriately. There's more that's happening. Cases aren't being resolved properly. The inmates at the jail are literally keeping a list of case resolutions in special victims cases. And our unit, they shouldn't have to take accountability because some other prosecutor wouldn't force them to take accountability. There was a first-degree sodomy case of a child, which is a 25-year mandatory minimum, and one of the line attorneys that he gave it to pled it out to a 1 to 15-year non-mandatory prison term. That is not justice. And I have to tell you the real reason the Special Victims Unit was gotten rid of. From whom? I sat in the room with David Leavitt. I know he's going to get 30 seconds to respond. That's fine. I sat in the room. No, I got to get this one out. He told me. No, I got to tell you.
Time. Ladies and gentlemen, the rules of this debate is that everybody gets an equal amount of time and rebuttal. If he wasn't able to provide the answer within he didn't provide, his response did not fall within the time limit.
How about this? How about this? I'll give Adam Pomeroy my 30 seconds so that he can tell you what he says I said.
Thank you.
It's not what I say he said, it's what he said. And go ask any person on the Special Victims Unit for the truth about what happened. I was told to my face that the reason it was disbanded, after he promised law enforcement not to disband it, is because there were some attorneys on the unit who wouldn't follow his softer on crime sex policies towards people. Because he wanted a case that the line attorney wanted to go to prison to not have to go to prison, that he should work out molesting his grandchild with an LDS bishop. That's not how we prosecute sex cases. Sex cases against children should go to prison.
So the next question. So we've heard about plea bargains a little bit. I just want each one of you to talk for 1 minute, I guess, on what your philosophy is regarding plea bargains. And we'll go Adam Pomeroy, David Leavitt, and then Jeff Gray.
Here's my philosophy. We do justice, and we do only that, and we do it all the time. Arbitrary numbers of jury trials won't take us anyplace, but in every case, seeking to do justice will. And I make no bones about it. There are times where plea bargaining is appropriate. When we've had a case where a victim is suicidal on the eve of trial, probably time we should be looking at a plea bargain. If it can recover the body of a small child who was murdered, probably should be looking at a plea bargain. If we can get the defendant to buy into a program, to say, Judge, I agree to do this, and you hold me accountable, we should have a plea bargain. But if someone wants a jury trial, all day long, I love doing jury trials, I will take that person to a jury trial and afford them their constitutional rights. Because what we do is justice, and do it individually, case by case. Thank you. David.
We talk a lot about justice. The truth is, you can't get justice unless you know the truth. And you can't know the truth unless you have the government prove the case. And that's the whole chicken egg problem. How do we know the guy's a sex offender unless we prove it? So what we're saying is we would rather put the thumb screws on somebody rather than prove the case. Now, I have a child sodomy case. I don't know what case he's talking about because that violates my plea bargain policy. My plea bargain policy is you plead to the highest charge and you get the consequences if you're going to plead. I took a child sodomy case to trial in December, had the opportunity to plead it out, but didn't. Spent a week in trial, got a conviction. He's going to prison for 25 years. This notion that I'm soft on this, it's just an absolute damn lie.
Rebuttal. Do you want Jeff to go first and then rebuttal?
No. Adam.
Jeff, the rebuttal.
Call me a liar? Great. Ask me for the case numbers after the debate. You can look it up yourself and you can see the truth. It's right there in public court records. This is what is going on under the current administration because he doesn't know what's going on under the current administration. Everybody knows this. Defense attorneys are calling me complaining about the good plea deals that they get for their clients because they know that's not keeping us safe. But respectfully, they have to do their job, and I don't fault them for that. I fault where the policies come from. I fault where the vision comes from, and you should too. Thank you.
The notion that the county attorney is not plea bargaining it's just a falsehood. It's happening at the screening stage. He doesn't charge what the evidence supports. He charges something less, and then he says you either plead guilty or we go to trial. Well, the Constitution, let's have a little constitutional instruction here. He's got a fundamental misunderstanding of what the Sixth Amendment provides. The Sixth Amendment guarantees the right to a jury trial, and that's not being denied anyone. If they want to go to trial, they go to trial. Why would we plea bargain? Well, if we have a child sex abuse case and there's 6 counts, 10 counts, or whatever, I'm charging them all. And then we will work it from there. And if that defendant can plead guilty and save that child from having to testify and go through the hell of trial, that is a good outcome. And the plea, by the way, as far as proof, is they take the plea and it's voluntary and knowing.
Time. Rebuttal from Mr. Leavitt.
This is just a simple fight, guys. What system you want? The system that the bureaucrats devise where you charge high and get a plea, or where they actually try the case and prove the evidence? Simple question. It's your choice.
Thank you very much. All right. We are coming close on time, and so this will be our final question, and then we will transition into 2-minute closing statements. It's especially pertinent because this is a question on the implementation of Republican principles as Republican elected officials. So, what is the role of an elected Republican county attorney in implementing Republican or conservative policies? Our order is Jeff, Adam, David.
We believe in the Constitution and upholding the Constitution. And we believe in upholding the law, the rule of law. That's my foundation. I love the law and I love the rule of law. And so when I take the oath as county attorney, I take the oath to uphold the law. And my primary responsibility is to prosecute those who break the law. So I am consistent with the Republican Party. That's what the Republican Party wants. The Republican Party wants to hold criminals accountable, and that's what I will do.
Within a county attorney's discretion to enforce policy, a county attorney should enforce the ideals of our Republican platform, the ideals of constitutional order, the ideals of the rule of law, the ideals of life, liberty, and property. Our Republican platform recognizes the central nature of families and the individual in our society. And the county attorney's policies, whether that's at screening or trial or determining charges or anywhere else, has to be focused on upholding those ideals. We hold offenders accountable, we individualize, to be smart about it, so our communities, our families, our children can be safe now and safe for future generations. Thank you.
When you take an oath to be the county attorney, which I have, which I've done 3 times, you swear to uphold the Constitution. And there is no one in any jurisdiction that has more ability to uphold that Constitution with respect to the speedy trial and jury trial than the county attorney. That is a fundamental principle of the Republican Party. Now, you've all heard, or many of you have likely heard of CPAC, the gold standard conservative political action committee in America. CPAC endorses me for re-election. Why? Because I adhere to the absolute certainty that the only way that America will continue to stand is if we return and restore our constitutional principles of the jury trial, which we are losing. We are losing.
All right, thank you. So, we still have a lot of questions here that you guys wrote down, but we're running out of time. So, what we're going to do is we're going to move into the closing statement phase, and then what I love about the delegate system is you guys are here, you're super interested, I can tell from your responses, right? Which is fantastic. I'm glad you guys are passionate and you have some opinions and you have some questions that we didn't get to that you want to ask. So I don't know how much time we have in this venue. 5 minutes?
Well, no, until 10 p.m.
Oh, okay. Well, all right. You guys, here's what I'm saying. I'm going to suggest that the candidates stay after a little bit, and then you guys can ask it maybe one-on-one or in groups or whatever, because we told you an hour and we've used our hour. So that's what I'm going to suggest, and I guess we can stay till 10 o'clock.
We're going to transition into our closing statements that are 2 minutes each.
I gotta say, that assumes that we don't have, we built this for an hour and I've made commitments with other delegates.
Right.
You can say I'm running away if you'd like to, but the reality is I keep my word and I go where I'm saying to do.
All right. So that's what we'll do, okay? So we're going to give we've said 2 minutes. Do we want to change it to 2.5? You guys want an extra 30 seconds, or you good with 2? 5 minutes? They're attorneys. They'll take the full 5.
Nelson, at your discretion, I suggest you keep it on the shorter side and let the delegates ask us questions after.
Okay. All right. Let's go. 2 minutes. All right. 2 minutes. So, and our order is going to be Adam Pomeroy, Jeff Graves, and then David Leavitt.
You've heard the debate, you've heard the issues, you heard me get passionate. I believe in this, and I believe we need to do better. We need to hire a new chief prosecutor in our county. And the best thing you can do right now is to hire a current trial prosecutor to do that. I love our constitutional system. I love teaching about it. I love doing it every day. I work with victims. I work with law enforcement. I work with offenders to make all of our lives better. Now, I've used this analogy with some of you. When your child is sick, where do you go? You go to a pediatrician. You don't go to a heart surgeon. You don't go to a neurologist. You don't go to some guy in the street corner who says good things but doesn't follow through. You go to the person that has the relevant experience. I'm in the office. I've built the relationships. We need to turn this office around. I've worked with law enforcement. We can get there. I know what the victims need because I work with them. I know the opportunities to enact smart on-crime policies to make us better. I've talked about domestic violence specialty courts. I've talked about some amazing programs out there that actually work, and aren't just $5 million thrown at something to see if it works, but there's basis and research and studies. We need to be doing better, and I'm asking you to trust me because I am the best candidate for this job. I have the right experience, and by being here, I know best of all who in the office to trust, who we can put back into the Special Victims Unit and have it done right. Who in the office can be our leaders. And simply, who in the office has a good heart and just needs more training, and most importantly, the right vision from on top to get it done right. Thank you.
You face an important decision, and I have the commitment to be the county attorney and to uphold the law. And I understand the law. I understand the Constitution. And I understand that what our responsibilities are as prosecutors. We have the responsibility to keep us safe in our community, to enforce the law and hold people accountable. What is my experience? I've been a prosecutor for 31 years, 7 years a trial lawyer, what he's reached. But I have 24 years of appellate experience, criminal appeals. Why does that matter? When prosecutors have a question about evidence, what arguments to make, what arguments to defend, what evidence is admissible, do you know who they call? They call me and those on our leadership team in criminal appeals. We are taking those calls and guiding prosecutors all the time. That's what I've been doing. That's the experience that I bring. I bring that experience not of only being a trial lawyer, but I also understand what it takes to make a conviction stick. We need that kind of leadership. We've had cases where the Utah County Attorney's Office, I said, this is bad, don't pursue this. They pursued it, and we recently lost on appeal. We need the vision, the broad vision that I bring. I am committed to this, and I'm committed to making this community safe. Thank you.
You guys are kind of a tough crowd. And I'm grateful to be here. And let me tell you why I'm here. I'm not here because I'm trying to get your vote. I'm really not. Why? Because this vote is not going to be decided on the 9th of April in the county convention. This vote's going to be decided in June among all the Republican voters in Utah County. As it should be, because this is such a significant issue. The issue is, which system do you want of government? Do you want the system these two subscribe to, of just lining people up and processing people and running them through? Or do you want the system designed by the founders, where we actually prove the evidence and demonstrate the evidence and prove the case? Now, the reason why this is going to be decided in June is because I understand that when you hold people accountable that aren't used to being held accountable, they come after you. And that's why the system is coming after me. Not because I'm a horrible guy, but because people don't want change. And they're not bad folks. People just don't like change. But the change that I'm advocating is the change to restore our system back to where it was. And so what did I do? I went and I collected 6,300 signatures to put myself on the primary ballot. And Mr. Gray, I presume he either turned them in today or he'll turn them in on Monday, because he also said that he's going to go to the primary ballot. And if he says he's going to do it, I presume he will. And so I'm here because I'm the county attorney, and I have an obligation as part of my oath to support and sustain and defend the Constitution of the United States. And I'm here to tell you that we're going in the wrong direction if you want to have a constitutional system, because we don't.
All right, we'd like to invite all of our candidates to come up to the front. We are so grateful for this hour-long debate.
National Medal of Honor Day to honor all of our Medal of Honor recipients. And Jose, who has anyone here ever heard of Jose Valdez? He is Utah County's only Medal of Honor recipient. And he's from Pleasant Grove. Yeah. And so it's kind of fitting that, you know, we have the debate here on the 25th, and I am also the commander of the Veterans of Foreign Wars Post, the Timpanogos Post, and we commissioned a portrait of Jose Valdez, and we've been putting it in schools all over Utah County. And we made a little dog tag of the portrait of Jose Valdez. And I'm going to thank the candidates. I'm going to give each one of them a dog tag of Jose Valdez. And as you go, as you leave, we have a booth set up so that if you would like to make a donation to help pay to put portraits of Jose Valdez in our schools with his Medal of Honor citation, for a $5 donation, we'll give you one of Jose's Medal of Honor dog tags.
Thank you so much. I'm sure our candidates will make themselves available in the tables and all the, that's where the snacks are. So really, that's where you want to be. I will steal a snack from every single one of you.
You already did.
Thank you, everybody. Please drive home safely and be sure to vote at the convention. Thank you.
So Adam.
Yes, ma'am.
So you did not.
No, I did not. Thank you. Only one. Right?
That says a lot about you.
I had a lot more to say.
The convention's gonna be a rough go, but the primary will be okay.
So I know you got to run. What's the best time to get a hold of you to ask more questions?
Do you have my cell phone?
Yeah, is that you have
Just,
time for it?
yeah, I mean, just text me. And,
Texting? Okay,
I mean,
text you. And
the best time is who knows when.
well, yeah, I don't know when you're scheduled.
But you know, I'll be a little late. Go ahead.
Well, you had mentioned a lot that you were saying that the crimes weren't being proven. Right. What can you expound on what you were meaning by that?
Yeah, we charge crimes.
Yeah, of course.
And then we charge really high, like these guys say.
Yeah, sure.
And then you drop them to get a plea bargain, but nobody ever hears the evidence.
Okay, so your contention is they're intentionally charging high to get plea bargains to pump them through.
That's exactly right.
Got it. So
every day.
Well, yeah.
So tell me your name.
Derek. I voted for you last time.
I had a question for you. I've been reading just a lot about each candidate, and I was wondering about your stance with child pornography. I have 4 kids, and there was an accusation that was made, like I put it in the questions because I wanted to understand it better, that there was, I guess, a child pornography case that you pursued as a computer crime, and I just wanted you to explain that because, like, I was like, I think it was in the letter from the Fraternal Order of the Police, and I just wanted you to explain, like, do you know what case they're referring to?
I haven't even read the Fraternal Order of Police letter about me.
Oh, really? You haven't?
I haven't, just because, you know, what they're saying about me is just so outrageous. At some point, you just have to turn it off. It's just not worth the brain damage. And so I don't know what case they're referring to. Okay. My philosophy is this. You know, you have to exercise good judgment to figure out what's dangerous, what's not, and you don't just simply say.
So under the law, what is defined as child pornography?
Well, child pornography is, generally speaking, is an image of a child in a sex act with someone else.
Okay.
Whether the person's a child or an adult.
Okay.
Or it may not be a sex act, it may be a naked picture that is sexually explicit.
Okay.
You know what I'm saying?
I understand.
A picture of your kids in the bathtub with their bare bum is not child pornography.
Yeah.
It has to have a sexual component to it.
Okay. Just because this is something that, like, I've been following nationally, I've been following what's been going on with the Supreme Court justices, and my biggest issue with pornography, with special victims unit, all of that, is I want a deterrent at the beginning of the problem, because I haven't read any evidence that suggests that when you're involved in child pornography, that there is reform. I know there's drug reform, I know there's other reforms, but as far as that, so I feel they should feel the full brunt of the law when it comes to children. And that's something that's very concerning to me.
Right.
Because as far as I understand, that's not being prosecuted right now in Utah County, and it's very...
Right.
We moved from California because of the problems we have in California. There's a child trafficking ring. We moved from Orange County, and I'm trying to pick
Does it make
and
sense?
understand.
Does it make sense logically that we wouldn't charge something like that? I mean, people will say we don't do this, we don't do that.
But I think it depends in other. I mean, obviously everything would be case by case.
Yeah.
Because if you, like, for example, in Orange County, I'm LDS. There was a woman in Huntington Beach who was taking pictures of nursery children and sending them to people.
Right.
Now, they may not be explicit in nature, but she was distributing.
Sure. I mean,
And so it may not, but you know what I'm saying? It would have to be case by case.
It couldn't be a child pornography case because it's not.
But it is. So it's
the law, right? Like the law doesn't say that's child pornography. It's not. If
but it's how it's being used, and I'm protecting children.
let me say this: if there's child pornography on a computer that victimizes a child, well, period. I mean, if there's child pornography on a computer that's victimizing a child, we prosecute. The fact that they say that they don't, I mean, it's easy to just, give me the proof. I'm not saying to you, I'm talking.
Yeah, I know
Yeah.
but it's just, I think that's something that I think, like in Utah County, like you have a lot of people that have moved. My sister, she moved from California. I moved from California. Lots of people moving because we're trying to flee states that don't have law and order. So when we come here and you hear things, it's very disconcerting, if that makes sense. But
it is, and you just have to, what you have to do.
Yeah, and my sister's husband is also a first responder, and so.
Yeah, what you have to do is you have to try to quiet all the noise of what people are saying. You have to look the candidate in the eye. You've got to get a sense for whether they're, aligned with you. And because every case, I mean, I have dealt with tens of thousands of cases over 30 years, right? Some of those cases are horrible. Some of those cases are dog bites, right? But how you deal with them is governed by the principles under which you. And my principles are, you lock up the violent and the dangerous. And are child pornographers violent and dangerous? Every day of the year.
Yes.
Every day of the year.
Yeah, and I think there's also violent criminals who can't be housed safely. And so that was another question I had. You have violent criminals harming other people that are actually in prison. What's the answer to that? And that's one question I wanted answered. No, because if they can't be housed, I guess I'm talking about pursuing the death penalty in certain cases.
The problem with
because if they're injuring other inmates, it's our job to protect other inmates. If they can't be housed safely, that is a huge question in how we're.
Yeah. The problem with the death penalty is that it works academically. Practically speaking, I'm a guy, literally, I'm the only guy in Utah County that's charged with the death penalty in 40 years. It doesn't work. It just doesn't work. Life in prison without parole, thank you.
But then you run into this
That's what
issue.
I'm saying.
Put them in solitary confinement.
Inhumane to them? Because they're
If we were gonna kill him.
You're going to kill them.
But I'm saying, but which, if
Yeah.
I had a choice, if I were a violent criminal, would I want to live in solitary confinement or pay for my crimes? I think I want to pay for my crimes.
The issue
Be a
here,
death penalty, you're saying? No, I agree completely,
Yeah.
but then the legitimate question comes in, are the bureaucrats stopping that, making it an outrageous process?
I'm just saying, I don't know,
that's
not,
the problem.
but not pursuing the death penalty is not fixing the problem.
Right.
Because that's not fixing the problem by not pursuing it. You should be pursuing it and trying to fix the bureaucracy.
Yeah,
and that's what I'm trying to say.
the problem with all of this, and again, I mean, I've been dealing with it for 32 years, all right? And the problem with a debate like this is you just can't discuss anything in any kind of rational way in 60 seconds, all right? The problem is that the bureaucracy is multi-pronged. It's not just the bureaucracy. You have this agency, this agency, this agency, and this agency, all of which have their own unique bureaucracy, and all of which is messing it up.
But I feel like you can't solve bureaucracy by not pursuing the death penalty, and that's where I think my issue is. Maybe what you're saying.
Right.
Shouldn't you be running for a state office where you can propose bill changes for what you're saying?
I don't think so because
the solution is not with the county attorney, it's with the legislature.
the best place to change the word from my opinion.
Bureaucracy by not pursuing crime.
But if they're pushing and making it the game where he can't ever win, I'm with you on the death penalty, but I do completely. But if they're not forcing you into a game, you have to play it.
Right.
What's the difference? Because both seem to be saying public bargaining.
That's a great question. A plea bargain involves the governmental use of coercion to say we're gonna do this to you unless you do that.
And how is that different from a pre-filing?
The pre-filing diversion program says do X, Y, and Z, and if you don't do that, then we will start the process against you.
Still coercion?
No, because we're going to do that to them anyway if we charge them, and then but we're not, when we charge them, we're not going to say we're not going to give them a plea bargain. We're going to charge them with what they had, and we're going to go try the case. So, I mean, I can see academically how it's a form of a plea bargain. I'll grant you that. But what happens in plea bargains, and what these guys, really don't want to face, is that prosecutors will charge 20 of something. They'll reduce it down to 2 or 3 and really what they believe is that their job is to force that plea. Right? Their job isn't to force that plea. Their job is to prove the case and let somebody else decide. And so, the problem with the pre-filing, the problem with the system that the pre-filing diversion solves is that the system does not give the nonviolent any kind of consequence now. And so their solution is let's just keep throwing criminal charges at them and make their rap sheet this long, so then maybe they'll go to jail for a year, right? That doesn't solve anything, particularly when they're not, and it costs us millions of dollars. What I'm saying is, you have this pre-filing diversion program, you do something stupid, and we give you an opportunity to go pay your debt to society, and we do it on the front end to give you the opportunity not to be a criminal.
Are all community service,
yes,
some sort of reparation based.
Yeah, community service, counseling. We give you an assessment, and we give you a penalty that's designed to change your behavior, rather than designed to put you in jail, where you're going to learn how to be a bigger criminal by the people who really are criminals.
And you say we will prosecute you with, or charge you with this crime unless you complete.
Right. Now I've done this for 3 years now. All right, with no funding, we just kind of pieced it together. We had 3% of the people that successfully completed our pre-filing diversion program reoffend. Now 4% to whom it was offered, the punishment was so severe that they said we'd rather go through the criminal justice system, and we sent them through the criminal justice system. And the fundamental problem here is that when you think of countries that don't prove the allegations that they make against their people, you don't think of America. But we don't prove the case to the point where during COVID, 94% of state Supreme Courts, including Utah's, actually suspended the right to a trial by jury. What kind of country is it, right? And you know, I think these guys were pretty forthright that they're here to support the police. Well, you know what? I'll support the police. I do support the police, but when they do something wrong, I won't. And I've been in this position. You know, I served for 8 years. I now have served for 3.5 years. I've had 20 some odd years in between those times. I left the criminal justice system. I went to Ukraine and started working with the Supreme Court of Ukraine to reform the Ukrainian criminal justice system. What I learned in Ukraine is that it's our future. It's our future. Do you know who had we have the presumption of innocence, right? You're innocent until proven guilty. Do you know who else had it? The Soviet Union had it. You know, the presumption of innocence means nothing unless you go through the checks and the balances to enforce it. And who does that? It's the county attorney. And the county attorney, if the county attorney is scared of what the populace is going to say, when the police come out in full force against you, that check goes away. And that's where we are. That's where we are, yeah.
When I was looking for your website, I searched David Leavitt, and there was a declaration of no confidence from others that used to be in your office. And I'm just curious what your rebuttal essentially on that.
Right. And first off, they filed a letter of no confidence against me because when I took office vowing to change the system and get rid of them. And they're all merit employees, so you just can't go fire people, right? I changed the policies, which are very clear, and then I took them out of their leadership posts, and then they left. And they left and have no confidence in me because I demonstrated that I've got no confidence in them. And what I did is I replaced them with people that have actual solid trial experience. A Los Angeles DA with 90 jury trials, a former elected district attorney from Kansas and Nevada, a trial lawyer from Kentucky and from New Mexico. I mean, people in America that understand about the right to a trial by jury understand that really Utah County may be the last stand for enforcing our juries. Why? Because if a guy who's conservative, who's endorsed by CPAC, who has 30 years experience, who has the political will to stand up to the forces against him, and the independence to not be beholden to the office, if I can't break through this logjam of bureaucracy, no one ever will try. So I may not simply be the best choice of restoring our jury trial. I may be the last choice, the last opportunity in all of our lifetimes.
The two things that were specific there that I'm curious about are, they were saying, I think that there are 45% less cases of actually
less felonies.
Okay, felonies less felonies. And then there's like a $5 million more.
Okay, let's peel that back.
Please do.
Let's peel that back.
But before you do that,
yes.
Where can I find those kinds of statistics, those kinds of numbers?
Which kinds of statistics? I'm sorry.
What are you saying? 45%, which felonies, all those kind of...
That's what's one of the problems with criminal justice is that no one keeps any records. And I mean, you can find a specific record on a specific case, but you can't look at broad trends. And that's one of the changes that I made, is that I got rid of one lawyer and I hired a team of statisticians to come in and start keeping data so that we can keep track of things that are important in criminal justice. So where can you find these things? You know, not very many places, frankly, because we're one of the only places in the country that actually monitors itself to such a high degree with statistics.
Do we have access to those statistics?
Well, we're a work in progress. I mean, some of them, yes. I mean,
what's the best place for whatever is available?
Well, the best place is to text me, and whatever we have, we'll give it to you. Right? Okay, I mean, here's. I mean, we are priding ourselves on transparency. For example, when we talk about screening cases and deciding what to charge, These guys talk about that like it's just a rubber stamp of what the police want, right? We've got to process these cases through. There is not a more serious and consequential decision in a person's life than what the government is going to charge you with. And that demands for everybody the solemnity of that process to decide what are we going to charge this person with, right? It's not done in secret. It's done every day. We film it on Zoom. We meet on Zoom so that we can record it. Everything is recorded. And if anyone wants to see why did the county attorney charge this, or this, it's there for people to see. Now, to answer your question, you have to dive a little bit deeper here to understand the nuance, which we all will get, but we have to start a little differently. A misdemeanor charge doesn't carry with it the same penalty to society that a felony charge does, right? A felony, it's, you can't get a job, you can't get a place to live, you're done in most respects. Now, a misdemeanor, we will forgive as a society. Now, in the criminal justice system, what these guys really, again, this debate is more of a disservice than anything because you get to launch these grenades in 60 seconds and you never get to talk about the issues. A court will give the same sentence for a misdemeanor as it will for a felony. It's the same sentence, okay? Now, if I charge you with shoplifting as a Class B misdemeanor, you can get 6 months in jail. If I charge you with a felony for the same shoplifting, and Mr. Gray's wrong, you can, through multiple offense, get shoplifting as a felony. That sentence could be 5 years in prison, but what the judges do is they sentence both of those as if it's shoplifting, and they'll give you community service and no jail time, okay? Because there's not room in the jail to put a shoplifter, right? And so when the person walks out of court, they walk out with the same sentence, but one of them has a felony on their record and the other one has a misdemeanor. And the real consequence of a felony is that 20 years from now, you still can't get a job and you still can't get a place to work, right? So what I'm saying is we need to be more circumspect in how we deal with nonviolent criminals. Rather than give them a felony so that they're always going to have, that trailing them, what I do is I charge them with a misdemeanor in a different court. They get the same sentence in that court as they'll get in the district court. The difference is that one will forgive, the other one wouldn't. Okay, so now let's get to the numbers question, right? I charged 51% fewer cases in the felony court, and I charged 61%, I charged 161% more cases in the misdemeanor court. So it's not like I'm not holding people accountable. I just chose the court where they're going to be prosecuted so that they can pay their debt to society and not have a felony.
Do you have statistics before your election and after your election of recidivism rates in Utah County?
No, and nobody does.
Mr. Leavitt, I'm a delegate, one of your delegates, and somebody sent me articles about a federal case against you where you're accused of dropping charges against a family friend, and another one about you're accused of abusing your office by calling the sheriffs to go lenient on your family handyman or something.
Right.
Are those just like you're saying, like the system coming after you because of your policies, or is there some merit to those?
There's no merit. Let me describe in complete transparency what everything is, okay? And again, this is an example of what the system will try to do to try to besmirch, or whatever the word is, to try to just smear somebody, okay? That case, let's talk about the handyman second, okay? Okay. That case was a case of a stalking case, where a guy was stalking a victim and completely trashing her on social media. It was set for a jury trial. It was set for a jury trial in like 3 weeks. It was during COVID, and because the Supreme Court of Utah suspended jury trials, that case got postponed. And so now I have a victim who's continuing to be trashed on social media, and she can't get any relief, and she can't get a jury trial, and she won't for the next 2 or 3 years because it's now in the bottom of the queue, right? And so in trying to find relief for that victim, I went to her and I said, let's dismiss this charge against him without prejudice. What does that mean? It means that I can file it again. And the condition of that is, if he says one word to you in any public forum, I'll file the charges again. All right? She agreed to it. I've got 72 pages of text messages where she agreed and compliments me on how I dealt with the issue. All right? That same guy happens to be 35 years ago the missionary companion on an LDS mission to my brother. Okay? Don't know the guy. And that was the connection. He went on my website when I ran for Attorney General in 2020, and he donated $49.99 to my campaign for Attorney General. Now, why did he donate $49.99? Because you don't have to disclose it if it's under $50. Why does everyone know it? Because I disclosed it. I said, this guy gave me $49.99. Well, okay, the guy, after 6 months, goes in a public forum and starts trashing this woman again. And what did I do? I refiled the felony charge against him. Okay? I put him back in the position and put the victim back in the position. So, okay, these bureaucrats that, and listen, that woman, the system has done her wrong, right? She deserves to be able to have her trial. She deserved to have this issue resolved. But when the Supreme Court canceled her trial, there's no remedy. And so she's mad, right? And these people come to her and they say, hey, we'll sue David Leavitt and allege all these things in federal court. Why did they do that? Well, they did it so that they get a big media event and they can sock me right in the nose on statewide television. And then what do? The day before I have the opportunity to answer the federal lawsuit, they dismiss it. They dismiss it. So they get the publicity. Guys, I've practiced law for 32 years. I've never had a bar complaint until the last 4 months. Now I've had 4 in 4 months by people who are trying to do anything to try and let's ask that question. Why are they fighting this so much, right? Well, first off, they're good, honest people that actually have been raised to believe that the system is about giving plea bargains, right? We've forgotten any notion about proving the case. That's the first thing. The second thing is that it's easier for everyone in the system. A prosecutor doesn't have to prove a case. He can give a plea bargain in a half an hour. Boy, why wouldn't we do that? A defense attorney, he or she makes the same money based on the flat fee, regardless of whether it's a plea bargain or you go to court. Why is that? Because the defense attorney charges a fee because he or she, it's dependent upon the relationship that he or she has with the prosecutor. I mean, I literally fired 3 lawyers in my office, 3 of those people that, those people didn't sign the letter, but I fired 3 people in my office who were accepting Jazz Lakers tickets from defense attorneys at the time they had cases with each other. Now the police here are the victims in all of this, right? The police want to do the right thing, but you make a logical decision with the police. If you're the police and you keep investigating these cases, you make a logical decision that says, why should I investigate this if the county attorney is just going to plead it? So they stop investigating cases. Now you have to plead it because there's not the evidence to take it to trial, and it becomes this vicious circle. And that's why from 1969 we had 75% plea bargains. In 2019 we had 99% plea bargains. It's also why in 1969 we had 200,000 people in American jails, and why today we have 2.3 million people in American jails. We have more people in American jails than any other country in the world. Now, what percentage of those 2.3 million are violent? About 10% of them. 90% of them are not violent people. They're mentally ill. They're addicts. They're people that were victims first and then perpetrators second. They were, today's perpetrators are yesterday's victims. Now, yeah, that's true. I mean, folks, we are not going to change this criminal justice system ever, unless we get down to the very basic premise that the government always proves the case against people.
And what's your plan then to get back to church?
The plan is this pre-filing diversion program. Did you ask about the $5 million?
Yeah.
The plan is this. You charge the most violent and dangerous people. You prove the case. The non-violent, the non-dangerous, you take through this pre-filing diversion program that says we're going to give you a swift sentence on the front end, and if you don't do it, then we'll send you through the traditional way. And so you're giving people penalties on the front end and allowing them to move on with their life. And that's a far better approach. The $5 million goes to pay for that pre-filing diversion program. Now, how do you fix that? Well, listen, the sheriff's office has a $65 million budget in Utah County. It's it's like, I don't know, over half of our budget. 15 or 20 million of that amount goes to housing people in jail. How do you pay for the pre-filing diversion program? Well, when I took office, there were 750 people in the Utah County Jail on a daily basis. Today, there's 400 people in the Utah County Jail on a daily basis. What's our jail budget still? Still $15 to $20 million, right? Why? Because the county commission doesn't really want to tick off the police by saying we're going to put this from here and move it over there and sort of spit on you. Now, when I'm done with the pre-filing, when the pre-filing diversion program is operational, we'll have 100 people in the Utah County Jail. Every one of them will be violent and dangerous. The non-violent will be out with these programs. How you pay for that is you just reallocate the jail money to the we help you get better
So
money.
you're essentially saying it'll take some time.
Yes.
But eventually it will get
This is something, when I say we're never going to solve our problems unless we get to the basics, we can solve this, but it's going to take a generation to do it. And this is their best shot at me, right? I ran in 2018. I got 58% of the vote. Now everybody knows what I'm about, and they want their system back, right? They want their system back.
Who is they? And why are these two?
These two.
Okay, why are these two against you when obviously the media is, right? But why did they buy into it?
Prosecutors want to prosecute.
Well, first off, Jeff Gray and Adam Pomeroy wants to say he was a criminal defense attorney. I mean, he's been practicing law for 10 years, and he's been in the county attorney's office for like 7 of those, and he had a think tank job before that. He may have defended for, a year or something like that. I bet he has never had a jury trial as a defense attorney, right? I mean, his whole experience is as a prosecutor. Adam Pomeroy, smart guy, decent guy. Jeff Gray, smart guy, decent guy, right? This isn't about who's a bad guy and who's a good guy. It's all about perspective, right? It's all about believing. What has Jeff Gray done for his entire career? He has sat in a government cubicle defending government searches, the legality of government searches and seizures for the past 20 some odd years. He said it tonight. My job is to support and build the police, right? Well, I agree with supporting the police, but I also believe that I ought to hold them accountable. Why do they oppose the whole concept? It's the same reason why the Ukrainians do, right? I spent 14 years in Ukraine. Ukraine has a right to trial by jury. There's never been a jury trial in the history of Ukraine. Not one. Why? Because no one knows how to do it, right? No one knows how to do it. No, and we have this system. I have a colleague who's an 85-year-old lawyer who told me that by the time he'd been practicing law 10 years, he'd had 80 jury trials. You know what? My team, you don't have 80 jury trials in a 200-year career now, because we just don't do them anymore. And here's how these criminal charges work, all right? Person says something, you say that she did something. right? The police officer writes it down. The police officer comes and arrests you. They don't really interview you necessarily because you say I'm not, for whatever reason. The police report comes to me. The county attorney's office reads the report and says, well, I don't know your name. Yes, Sally says Sally says this, sounds good. Look at all these things that Jane did, right? So we're going to charge all these things. We're going to charge it. The police believe it. The police believe it. We believe it. Maybe it actually happened, right? I don't know. But the process isn't that we determine what happened in an office. The process is we say, yeah, this sounds reasonable, this sounds logical, so let's make the allegation. We'll take it to a jury of her peers to see what the evidence says. And then you put, people get on the witness stand, they do cross-examination just like we see on television, which is the only time you ever see it because it doesn't happen in a courtroom very often. And it's through that process that citizens get to understand whether people are guilty or innocent. And what is that process? That process is a check on the county attorney, right? Now, there are two checks that have been completely erased. Number one is the check on me. I have the power to investigate anybody, charge anybody, give a plea to anybody, and I have complete immunity for that action. I have no accountability for it. That's what makes these guys so angry, because I'm actually trying to do it with some, judiciousness, right? Now, what's the other check? Well, the police, they can do it. If the police say they're going to do it, they're going to go do it. And if the county attorney doesn't stand up to say, no, guys, we don't do that, then you see that we've lost two checks, both of which run straight into a police state. Now, we don't want to utter that word in America because that's just too dirty of a word for us to think about, but the truth hurts. And there's no shame in acknowledging where we are. There's only shame in denying its existence. And so what you get, if we get the same scenario, you say that she did that, either one of those people or the county attorneys, you're going to get charged. You're going to get charged way up here with everything that we can possibly find on you, and then you're going to make an economic decision, whether you're guilty or whether you're not. You're going to make an economic decision to enter a plea so that you can just get on with your life. I'd rather spend a year in jail than 20 years in jail, and it happens every day. Now, prosecutors, they don't want to. Part of the problem is it's an emotional thing, right? As human beings, we don't like to admit when we've screwed it up, right? I mean, I've got 8 kids, and my oldest is 32, and my youngest is 5. That's a different story altogether. But I'm flipping burgers. My son's home from West Point for a weekend, and we're flipping burgers, and he says, "Dad, you're a great lawyer." Thanks, Adam. That's nice of you. You're a great lawyer. And I kind of thought I was, I'm nothing special, but I thought that I'd done a pretty good job as his dad, right? I mean, he's, went on a mission, West Point, we've got a good relationship, blah, 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 blah. Well, Dad, you're a great lawyer. Thanks, he said. You weren't much of a father. But you're a great lawyer. And in the millisecond that I had to decide if I was going to really show him what a great lawyer I was, and I decided to listen. And in listening, I learned that I really had done things that had affected his trajectory in a significant way, and allowed a chance for me to change and to grow and to heal. Now, I left the criminal justice system in 2004 in complete frustration. I went to Ukraine. It took me 14 years of that process to realize how wrong we have it in the United States, because we're not following the system that the founders designed. And I'm coming back here and I'm telling everybody for the first time, guys, we're getting it wrong, we're getting it wrong, we're getting it wrong. Everybody, almost everybody that's not associated with law enforcement on the outside of the glass of this system understands it and gets it, right? That's why I'm going to a primary election, because the vast majority of these people get it. People who, you get 1,500 people, You can stack caucuses with people that just want to get rid of people, right? That's what you saw here tonight. And my job is to look at people, look them in the eye, be accountable for what I say, be accountable for what I do, and just speak the truth.
Question on the pre-filing diversion program.
Yeah.
How do you make sure that's not an effective form of double jeopardy?
Well, if they do it,
Then
well, first off, if they confess to the crime during that whole thing, of course, we don't hold it against them. You know, this is, you know, we take the evidence that we had before we do the pre-filing diversion program. We take that evidence, and then we put it on a shelf, and we don't collect more during the pre-filing diversion program. This is not a mechanism whereby we can get more evidence on you, right? We give you an honest chance to help, to fix your problem. If then you've done what we have agreed on, we give you a letter that comes from me, the county attorney, that says we are declining, you know, we are giving you a letter of declination so that we're not going to prosecute.
And that's legally enforceable against future attorneys and stuff?
Yes, it is.
So effectively,
and that's if you want to see the doctrine of that, look at the Bill Cosby sex crime, right? Because one prosecutor says they gave him a declination, another one came in, and not all declinations are binding, but that kind of declination is binding.
Okay,
Yeah,
another question.
yeah.
I could be wrong on this, but
Can I interrupt you one second?
Yeah, of course.
Skylar, if you're waiting for that box, I forgot it.
Okay.
I'll give it to you tomorrow. Okay, you want to hang around, great, but I don't want you hanging around for that box.
Mix of both, so that helps.
Okay, go ahead.
So in 2018, I was also a delegate, and I remember learning some about you back then.
Yeah.
But I thought that you were in Joab County for like 20 years going up to that, but you're saying Ukraine. So I'm just wondering.
Yeah. Let me give you the history.
Let me give you one more question that's kind of related, and that is,
I forgot the handyman
did you
story,
ever
too.
try a similar system in Joab County or somewhere else? And what did you learn, or how did it go if you did?
Right. Here, those are great questions. Remind me to tell you the handyman. Actually, the handyman story relates to Joab County. Okay. Here's the history. I went to law school to join the family business. Okay. I had no interest in criminal justice. I took a class from two Jewish defense lawyers at BYU Law School that completely lit my fire on the concept of criminal justice, and I had the hard conversation with my dad that I wasn't going into the business, and then I opened a law practice with my wife, who's also a lawyer, and I started the public defense contract in Fillmore, Utah. After 3.5 years there, I became the youngest county attorney in the state at the time, at 31 years old, in Joab County. Now, and because I hadn't planned on being in criminal justice, I didn't know anything about criminal law. All right, I was kind of dangerous as a defense attorney because I was learning the ropes, and as a prosecutor, excuse me, I didn't have the courage. I was a young 31-year-old kid. I didn't have the courage to stand up to this police force, right? And in complete candor, Adam Pomeroy's a good guy, a nice guy. His dad was the police chief of Los Angeles, okay? He has this notion that you've got to do this, and he's also too young to have the emotional fortitude, in my opinion, having worked with him, to stand up and say, no, we're not going to do this. This is wrong, right? There comes an emotional maturity to do that. Well, you know, I didn't have that as a 31-year-old county attorney, and I believed, and I got into a plea bargain system when I was given plea bargains left and right, right? I mean, it's just what people do, and you start to believe that that's what's right. And one of those plea bargains I gave was a guy named Dale Bowles. He's an 18-year-old kid. And Dale Bowles, I prosecuted him for possessing marijuana, put him in jail, put him on supervised probation, and it might have been a felony, actually, now that I think about it. I don't remember, but at some point along he got one felony. It might have been at my hands. I don't know. But you'll want to hear this story. This is a really good story. Don't leave.
Yeah, I got to talk to some people, though.
Thanks. Okay, I'll try that. If you have to leave, go ahead. He went on his way, right? I went on my way. I lost my next election for my third term by 22 votes. Why? Because I started to understand this whole notion of checks and balances, and the police came after me and they got me. All right? And I also prosecuted Utah's first polygamy case in 50 years, a guy named Tom Green, that also kind of cost me my election. With 22 votes, anything can, right? My brother was the governor. I lost 22 votes from that, right? I mean, the fact that, I mean, it's just, I mean, you can't, I mean, I love my brother, but we disagree on a lot of things. But I left office, I became a criminal defense attorney again, and I'm sitting in a jail cell when my client gets a life sentence in federal court for something that he would have gotten a 12-month sentence for across the street in state court. And I just thought, man, this system is just so whacked out and so crazy, and I'm burned out, I'm leaving. And I went to Ukraine with my wife and then 6 children to help the Ukrainians implement their criminal justice system. We got there 10 days before the Orange Revolution of 2004, which changed my life. And instead of being there for a year, I stayed 14 years. All right? Now, I came back because my wife went and got a PhD, and now she's teaching at BYU. She's teaching healthy sexuality at BYU, which is a different story altogether, but I'm back in Provo, Utah, and I'm deciding what am I going to do with my life. And I'm thinking to myself, why am I traveling 7,000 miles to try to fix somebody else's criminal justice system when I know what's wrong with my own and I can fix it? So I decided to run for county attorney. I run for county attorney, I get elected. Who do I run into? A month after the election, Dale Bowles, the guy that I prosecuted in Juab County. And I said, Dale, I remember you, I prosecuted you. And he said, yeah. I said, well, tell me about your life. Well, I've been on probation or parole for the last 22 years. I said, really? He said, yeah. I said, well, what are your offenses? All of them were driving on suspension, driving on this, driving on that, nothing violent. The state of Utah had paid to put him in prison, to keep him on probation for 22 years. And he was on parole. And I said, Dale, you're on parole. That means you have to have a job. Where's your job? I don't have a job. No one will hire me. I said, Dale, you're going back to prison. He said, I know, but no one will hire me. I said, okay, you have a job, Dale. I said, what's my job? He said, you work for me. I hired Dale, a guy I prosecuted, to come do jobs around my house so that I could give him employment and try to get him off of parole. Now, part of what I talk about is redemptive justice. We have to not only help, see you later, thanks. Thanks for staying. We not only have to help redeem people to a higher state, we have to redeem ourselves for how poorly we've dealt with criminal justice. And Dale Bowles was my aspect of my self-redemption, to take something that I had started 22 years earlier and finish it. And the proudest day of Dale Bowles' life, and frankly one of my proudest days, is when Dale Bowles brought me the certificate of completion of parole and said, David, thank you for getting me off of parole. Well, I told that story my first day in office as the Utah County Attorney. And do you know what that did? The bureaucrats that don't think that there ought to be any kind of redemption painted a bullseye around Dale Bowles, and they started, and they talked to their cop friends, and they started targeting Dale Bowles, and suddenly Dale Bowles starts getting stopped and searched, and Dale Bowles relapses, and he goes back on drugs, and he gets arrested. He's driving his mother's car, and I'm talking, and this is before I'm the county attorney. No, actually, this may have been after I'm the county attorney. He's driving his mother's car, and I get the police officer on the phone, and I say, this is his mother's car. Do you really have to impound his mother's car? Can't you just leave it on the side of the road and let her come pick it up? She's been dealing with this drug-addicted person for 40 years. Do you really need to make her pay an impound fee? Now ask yourself why does someone say, no, I'm going to go impound that car? Well, there's another side of the lie. I dealt with tow truck drivers this last week when tow truck drivers call up and say, you know, police deputies have their favorites. They call up and they'll give the tow job to their buddies. It's a little perk that they give. And so they take mom's car and they tow it, right? That was the special favor I sought for my handyman. The next thing I did for my handyman was that I sent a text to the Salt Lake County District Attorney, and I said, Mr. Gill, Actually, I called him Sim. Sim, my handyman just got arrested for possession of drugs. I can't prosecute him because he's my handyman, will you? And I sent the case to Salt Lake County. Now, no one in the media wants you to hear that story. The people who are trying to prevent me from changing this system want to make it sound like I'm giving favors to my friends. I'm not. I'm not. Other questions?
Thanks for answering.
Yeah, you're welcome.
Yeah, so our current system, issues with it going on. I have a family member who was raped and she accused somebody of it. And anyway, she explained the situation to the police officers. This was 6 months ago. Nothing's happened. We've called multiple times to try to find out where the heck is the case, and it's always, oh, I don't know, or it was with them, we haven't got it. Anyway. Why is this such a disaster?
Okay.
Her life is held up.
Her life.
Because of something that happened 6 months ago, and justice is not happening.
I'm going to stretch my legs here a little bit. That's okay. You've just identified maybe one of the single most problems, other than not proving our cases, in the criminal justice system. And let me talk about statistics that I know about because we created them in our office. Okay, well, the first one I didn't create. 1 in 6 women. Only 1 in 6 women report a sexual assault. So that also, you also understand that, so the only people that report are what? 12 or 13% of the people that are sexually assaulted, right? So if you take that category and you say, okay, a woman who reports a sexual assault, she goes to the police, she goes through the ignominy of the rape exam, and then she looks at the police officer in the eye and says, I want this case prosecuted. 77% of the time in Utah County, that case never leaves the police station.
We found that because we've called.
77% of the time, that case never leaves the police station. Now, I wanted to know why. All right? One of the reasons why was that the SVU unit had a 400 case backlog that spread 3 years back in my office. That's why I got rid of the SVU unit. Now, you know, nobody wants to tell you that, right? Now, then the next thing I did was we went to the police and we said, guys, do you realize that 77% of the time that you receive a sexual assault allegation, we never see it? And what do you think the response was? Immediate anger. It's not our fault. It's the victims this, it's you guys that, it's this, every reason under the sun. Well, okay, guys, we're not here to point, we're not, you know, I'm trying to work with these people, right? And so what we did was we went into the law enforcement system called Spillman, and we created a new code. And we said to the police, every time someone comes in and reports a sexual assault, we need you to put that person in as a code in that this person has made a report. They fought us on that.
Why? What did they say?
It depends on who you talk to, but you know, suddenly, this was the answer that was the funniest to me, that I thought was so ironic, was they said, well, that identifies that person as a suspect and a criminal, and he's presumed innocent. I said, no, it doesn't. It just says he's a suspect, right? And really, what it reveals is that the problem with sexual assault, at its core, is that the system looks at this from a man's perspective, not a woman's perspective.
Okay.
All right.
Tell me more.
And so we insisted. And so they started putting the codes in. Some people do it, some people don't, right? Some agencies do. It just depends on how much they're willing to work for it. Then what do? We went and we used state funding to find every rape kit that was sitting on police shelves, and we had them all tested. If a woman's going to go through the trauma of having a rape exam done, who are we to say we're not going to test it, for crying out loud, right? So we tested them, we put them all into a database. Well, there was a hit on that database because of our efforts, and we found a guy who faked his death in America, fled to Scotland to avoid a rape charge in Utah County. We took a case that was a 2012 case that was reported to the police, never sent to the county attorney's office. We tested the kit. 7 years later, we got a hit. We matched up in the database. We found the suspect. He's sitting in a Scottish jail today, awaiting extradition to Utah County. Now, if you Google Nicholas Rossi or Utah County Scotland rape, you'll see all this, right? Now, what's the next thing that we did? Well, the next thing I did was I changed the screening of sex crimes. I'm not going to have a sex crime analyzed by some 42-year-old chauvinist who's the only person making that decision, right? So what I did was I have a screening division, and anytime there's a sex crime, that case is screened by a team of men and women prosecutors so that we get a full-fledged perspective. Now, we still don't, I mean, I had a heartbreaking rape case that we're just in the process of declining because it was a woman who was out partying with her friends, and she wakes up, she's passed out, she's tender in her vagina area, she thinks that maybe she was raped, she feels yucky. But the best testimony she could give was
Good, how are you?
Good. Where were
Tiffany
you? Were you over there? Hey.
and Stephanie. I was right over there, yeah.
Good job. Oh, are you live still?
Oh, I'm live right now.
Hi.
Okay, you're live.
Hey. Adam's boss. The best.
Thanks.
You're
you guys
awesome.
are local celebrities.
No,
I'm
you're
just going to
not.
catch up with these other guys. Yeah, it was. That was fire.
I went through a program.
See if we can catch Jeff Gray here.
Anyway, nice talking to you guys. Thanks.
Good questions out
Are you gonna be posting all that?
Yeah.
Okay, awesome.
Yeah, it's
What was
all-
your name again?
Adam Bartholomew.
Adam, yeah. I've seen your stuff on Facebook, so, and I've seen you at all the different things, so.
Just trying to get as much out there as I can.
Were you filming this stuff?
I filmed all of it, yeah. I asked him about
What
some
other
local.
lies did he
I asked him about some local news stories. So.
What stories?
There's a couple of them. There's one where there's federal charges against him for
heard about this.
dismissing. He dismissed the prosecutor. Took over a case, and then dismissed the charges against a guy who was accused of felony stalking and was going to go for prison time. The prosecutor was, and it turns out the guy was a family friend and a campaign donor to one of his campaigns. Yeah, it is. So, and he has a bunch of reasons why he wasn't rallying things, and he ended up refiling. I think he ended up refiling because all the stuff came out. And he says that he has 60 pages of text from the victims and how well he the case. But then he says that the victim is working with the federal prosecutors to come after him because the system's out to get him. So, and then I asked him about the case that was in the news just last month where he's accused of abusing his office by calling up the deputies and asking them to go lean on a guy that's his family handyman.
What? I had not heard this one at all.
You know, and he has a story about it and says, it's about a guy that is a nonviolent, guy that he had prosecuted 20 years ago for drugs, for marijuana, but he's been on parole, in and out of parole ever since. And basically that the cops know knew that he's his personal handyman, and so they painted a target on his back, and they're out to get him.
That's how I usually go after
When you
people.
look
They're
up the guy, I
chauffeurs, they're
researched the
maids,
guy.
they're handymen.
Yeah, I looked up the guy. He was just arrested again back in January 27th of this year, and January 20th of this year, and January 6th of something like. And he's driving without a license, driving possession of drugs, possession of paraphernalia, possession of controlled substances, all these things. And he's like, oh, it's just because he's driving around without a license, like.
Just?
Yeah.
And with all these. Just because he killed some people with a vehicle one time and he didn't have a license.
Maybe you're enabling this guy by, covering for him and all this stuff. And, at some point people have to get held accountable. He's all talking about holding people accountable. But he's like,
You gotta draw the line somewhere.
This guy was arrested. Get them out. This guy was like pages of and every one of them has pages of things like drug addiction and stuff. It's obviously a potential committing crime.
Well, it's good to know he's at his house.
So, yeah.
That's who I'd look for. Doing handiwork. Oh, when I was climbing up that ladder, put the Christmas lights all the way up top.
When I was looking at the guy up, I'm like, what does this guy have? Prosecutor. That's what I want to know.
That's it.
Yeah.
Thanks.
Yeah,
thank you.
Yeah. I'll edit it out.
That's right. Whatever will help when you get it.
Nathan!
There's the man, Rod Man, right there. Oh, thanks. Thank you.
The same thing happened to you.
There's our great sheriff right here.
So that's one thing that separated us.
I do have one question about so I do some sentence for when Leavitt does reveal overcharging.
Thank you so much. Jose Valdez, and this is a gun that I operated in Korea on the demilitarized zone, and that's my unit patch. Wow. And this is my, hey, how's it going? Yeah, and this is a unit that I was in, the 2nd Infantry Division Artillery.
Thank you so much. I'm just curious if we were to field in that argument a little bit.
Sure.
Like maybe your response is, yeah, I agree with that, but isn't that what defense attorneys are for? Is to say, don't agree to this, they can't prove it.
Yeah.
But what is the check against that?
Yeah.
What is the what?
What is the check? What is the check?
Well, okay, when we file charges, especially felony charges, they have to go to a preliminary, they have the right to go to a preliminary hearing. Okay, at the preliminary hearing, the state has to put on evidence, basically to show probable cause that the crime is committed and the defendant committed. Okay, and if they can't meet the low probable cause burden, then they toss it. Okay, so that's the check. I'm charging something that the evidence doesn't support. So that's the check. And quite frankly, I don't see a lot of that. All right? If there's 10 counts of sexual abuse, and the evidence supports that, I'm charging all 10 counts of sexual abuse. And apparently, I mean, under Adams, I'm not sure where he comes, but he says smart charging, so something less than.
He was a little vague and pithy.
Yeah. So I charge what the evidence supports, and then if you look at a child sex abuse case, why I'm going to charge 10 counts, and then at that point we're going to talk, and now I've got victim input, and we might agree for him to plead guilty to 5 counts and dismiss 5. Okay, after consulting with the victim, because
what role should victim input have in charging?
Well, we should be listening to them.
Just because I think of domestic violence, and I think of the girlfriend who doesn't want charges pressed against her boyfriend, and then they break up, and then he goes and abuses someone else.
Okay, I'll tell you about that in Salt Lake City. I had cases like that where, and it happened all too often.
Or he abuses the children, and mom doesn't want him to.
Right. All too often, because a lot of times in those cases, there's not like a lot of evidence other than the victim's testimony. And I'd always have a conversation with the person. I'm like, you either lied to police at the time, or you're lying to me now, right? I mean, but those are tough cases, because if that's your only evidence and they refuse to, then there's not much you can do. And that's when I would do like a diversion after I've charged, okay, to get them into anger management or something to salvage the case, right? Because, you know, you end up going to another, because there's nothing I can do if I can't prove the case. But I've taken cases where the victim said, I don't want to pursue it, but because I had other witnesses, all right, I pursued it. So if I can prove it, I'm going to pursue it. But a lot of those cases, you don't have that eyewitness.
That makes sense.
So anyway, do you have any questions?
Well, I listened to the debate. I like your stand. You know, my son got his master's degree in counseling. He works with these, drug cases. If they showed up to the meetings.
Right.
I thought that was a great idea. And he
Yeah, those are all good things. I just believe that we charge, hold them accountable, and then make sure that they go through the program, right? And then if they don't, then they have to pay the consequences. So, did you have any questions?
Yeah. People are saying the way the current system is, we're not getting enough prosecuted cases. Is that what's happening? There's not enough cases in abroad that we're getting prosecuted. Is that what's happened?
It is happening. I mean, I've talked to the sheriff, the current sheriff.
Mike, yeah.
Right, and I've also talked to several police chiefs, and like one police chief, like we submitted, I think I talked about this, and they submitted a child sex abuse case 11 months ago, and they still haven't made a decision. All right, so there's no charges after 11 months. That's unacceptable. And then there's a whole swath of cases that he's doing this pre-filing diversion that they talked about, where they're never charged. And then we have to take David Leavitt's word that it's successful. We can't do it that way. We got to hold them accountable.
Well, we got to take a little sidetrack here. Excuse me.
Nice meeting you.
Anyway, I'm still gonna call you, but that's why.
Kevin Stratton. Hey. I'm live streaming here. Hope that's okay.
Sure. How you doing?
Good. I'm a delegate down in Payson, so I don't think you're
Wonderful.
You're not in my district.
No, I'm not.
But
Provo, Orem, and Linden.
Yeah. I messaged you on Twitter. Would you be open to do a debate with your opponent, your primary opponent, Jason Christensen?
Sure.
You would? That'd be like a Zoom meeting.
Best way to message is send me a text.
Yeah?
Yeah.
Okay, I won't ask you to put your number out on the video.
Oh, it's 801-836-6010. It's out there.
Okay,
so.
Cool, thank you.
Send me a text.
Yeah,
okay?
I'd love to set up like a Zoom meeting or something.
Be great.
Yeah. Do you know him?
I do. He's through the years we've had some good conversations.
Yeah.
And,
okay. Cool.
Always appreciate someone that's willing to get involved and engage.
Definitely.
So.
Thanks for running.
Thank you.
Appreciate it.
Keep up the good work.
Yeah, definitely. And thanks for voting for the veto, by the way, for the override.
That was an important one.
It was very important. Yeah. I appreciate that.
Thank you.
Yeah.
God bless you.
Your Twitter audience didn't, though. Yeah, I noticed that when I was on there. No, somebody had just responded.
There's two. They're not like this
because of that. I was like,
you can't have that. You can't
have
that.
You got a pamphlet or something? Cool.
Yeah, there's my number right there.
All right, thank you very much.
Great job. As always. Well, everyone's already seen it on here.
Well,
it's live, right?
We're trying to get the info out there. Jeff Gray.
David's system's not working. His intents are good, but the implementation's not
Okay,
working.
this
Why?
is my concern. Can I tell you what my
Sure,
concern was
sure.
in the debate?
Okay.
Prove, okay, innocent, the law is innocent until proven guilty.
Right.
That's the law. What I heard from Pomeroy and from you, I heard the term prosecution, 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 prosecution. As a matter of fact, I don't think he meant it when he got up, but when Pomeroy got up, he said, as the county prosecutor, I'm like, I don't think that's what you're waiting for. I mean, I'm just sorry, but I know that that's a big issue.
Okay.
More prosecutions, but that's a concern for me.
But he's not. We are always required, if the defendant insists on going to trial. And by the way, the defendant doesn't have to demand a jury trial. I mean, David Leavitt wants everything to be jury trial.
Right.
And he wants to actually push them into
He
that.
doesn't want plea.
And he doesn't want plea. But
Why do you want plea?
well, I'll give you the example that I gave. I don't know what I said.
Okay, it's okay.
But child sex abuse. I'm going to take a look at a case, and if there's 6 counts of child sex abuse that the evidence supports, I'm charging all 6 counts.
If the evidence...
Always.
Okay.
Always. And let me tell you what he's doing. If there's 6 counts, he's saying, well, I would take a plea to 3 counts. I will take a plea to 3 counts, and so that's all I'm going to charge. And then I'm going to tell the defendant, you either plead guilty or you go to jury trial. That's his philosophy. So he's making that plea bargain decision at the charging stage. Okay? Not because that the evidence doesn't support charging all 6 counts, but because he thinks, well, it's fair to only do 3. All right? So why would I want to charge all 6 counts, even if perhaps I end up taking a plea to 3 counts? Okay, in a child sex abuse case, first of all, under his system, he hasn't even talked to victims and what they desire. But second of all, after consulting with victims, many times they would rather have a plea to 3 counts of child sex abuse than go to trial on that, so that their 7-year-old daughter doesn't have to go through the hell of that whole process. And that's a real thing.
Oh yeah, I know that. I know that.
And
around here.
And the other thing is, okay, the defendant can make the state meet its burden of proof beyond a reasonable doubt. That the defendant always has that right. If the defendant decides to plead guilty, and people were pleading guilty, by the way, back at the founding, they weren't always going to trial. Our courts, they're required to make sure it's a knowing and voluntary plea. So they go through a colloquy of rights. You understand that you're giving up the right to a speedy and public trial. You understand that you're giving up the right to have an attorney assist you at trial. You understand the right that you're giving up the right to confront the witnesses against you. So they go through all the constitutional rights, and then they say, so after he acknowledges, the defendant acknowledges, yes, I understand that, then he asks the prosecution, is there a factual basis for the plea? And the prosecution describes what happened, all right, and then he asks, is this what happened to the defendant? And the defendant says, yes, this is what happened, all right? So we're not skirting the system. That's a voluntary plea that we can rely on. And for some reason, he thinks that we should go to trial instead of having somebody say, yes, I did it. And the Constitution...
So the question I have then is, when someone has a plea bargain, and they say, yes, I did it, don't you generally, with a plea bargain, don't you generally have a lesser sentence? Don't you generally?
Not all the time.
But that's the concern.
Well, that's a
That is a
concern,
concern.
and that's one of the things that we look at when we do a plea. So let's say we have 6 counts and we plead down to 3. One of the assessments that you make as an attorney is, if I insist on going to trial, which by the way, then I don't have a guaranteed I mean, there's always uncertainty. You don't know whether you're going to get the conviction so there's the uncertainty of trial, and then you also look at what's the likely sentence. even if I do get all 6 counts. And a lot of times, you could have 6 second-degree felonies, 1 to 15 years. And judges can determine whether or not to impose those consecutively or concurrently. So if they're concurrently, it's just 1 to 15. That's all they serve. All right? If it's consecutively, then it would be 6 to 30 because you can't go more than 30 on those things. Okay, so, and the prosecutor is going to assess what's the likelihood based on their experience, because prosecutors have been doing this for a long time. They know what the judges are going to do. And if all they're going to end up with is 1 to 15 concurrent, it doesn't matter whether you get 6 guilty verdicts or 3 guilty verdicts, it's still 1 to 15. So that's another consideration that you take into account in the process. Does that make any sense?
Yes.
Yeah.
Absolutely.
So the other question I have,
keep that thought, because there's one more thing on that.
Okay.
Sometimes we might have concerns with the evidence, like a suppression motion or something, and so we'll end up reducing, the plea because there's problems with the case. Okay, so they might get a lighter sentence. I mean, that's something that you have to consider.
I know, I don't like that.
But
I don't like that.
Yeah.
I don't like that.
But if there's...
It's the process.
I know it's the process.
It's the reality of the
I know it's
deal.
a process. Can you hold that for me?
Okay, you had a
I
question.
know. Well, the question I have is, do you know or do you understand why? By the way, this is pretty awesome.
Yeah,
I want to
that
find
is.
it. That's pretty awesome.
That is.
When did he fight?
It was World War II.
World War II?
Yeah.
I want to find that.
Yeah.
Okay, so sorry.
That's
I just
okay.
saw,
That's
I saw
okay.
him
That's
and
a
I'm like, okay, the question I have is, from what I understand, that 50% of the booking have been dismissed. Now, why would you think David Leavitt would do that? Why would you think, why would you consider that he did that? What would be
That's why he's running.
No, I don't want you to talk in terms of how you're running.
Right.
I want you to think in terms
Try to
of...
figure out what he's doing.
I want to think in terms of why you believe he may have taken that route.
I believe that he's trying to help people. Okay, I do. Honestly, I mean, I'm not going to try to get into his head, though.
Well, you are a little bit.
Yeah.
You are a little bit.
But I mean, I try to just take them and believe the best in people. Okay.
Okay.
And so he thinks, okay, this is going to ruin their lives because they've got a conviction and so forth. And so I think he thinks...
Even after the evidence, if there's no evidence against this person...
Well, if there's no evidence,
then you do...
Yeah.
You do dismiss
Yeah,
it.
yeah.
There's evidence.
Okay.
Yeah.
But I don't know about that. I don't know if the 50%...
No, that is not the case.
It's evidence.
Yeah,
okay, the 50%
cases.
had evidences. Okay. So then the other question I have is if they had evidence, but I have a hard time with the idea that if I could go out there right now and I could come back in screaming, I was raped.
Yeah.
I was raped. And I could swear on Bibles and tears coming down my eyes that happened to me. Right? I could tear my clothes up. And yet the person that I'm accusing didn't do it.
Right.
But if that went to trial or if it was booked or whatever, his life is ruined.
Sure, that is true.
His life
That
is
true.
ruined. And so that's the only place.
I mean, I'll tell you right now, those are tough. Those are the toughest cases.
That's a hard one.
Because what we get a lot of times, I'm going to change the scenario a little bit.
Okay.
What I
Yeah,
see.
because
a lot of times, so they know the person. Okay, they met him at a party.
Yes.
And the defendant says, we had consensual sex, and she says
no,
it was rape. Right. So I would never want to be. I mean, that's a difficult
tough
case.
That's a tough one. And it can ruin a person's life if it was consensual. But
so we have to. Those are
tough
tough cases. We have to examine all the evidence because it's never as simple as that. there's usually other evidence that would suggest that he's lying and she's telling the truth, or vice versa.
If she goes to the hospital, does a rape case.
Yeah.
Although even then,
but see, they consented. He's claiming consent. But there's other things. I mean, I could go into detail. I'm not going to go into detail on some of these cases, but you know, one of the things that we look at, okay, in that kind of case is what is his history, okay? Because a lot of times, and this sometimes can be used in evidence and sometimes can't, but...
You mean like the Kennedys? No, really, I mean really, seriously.
No, I mean, we
Not
have
here,
guys...
But you go over...
We have guys that, I mean, chiropractors and others that there's accusations, okay?
Yes.
But then, all of a sudden, there's another one, and there's another one, and it's like, okay, there's a reason to believe. There's a pattern.
If there's several, if there's a pattern.
Yes,
Okay.
yeah.
Okay.
So those are some of the things, but those are tough cases. There's no doubt. I mean, I mean, one of them, because rarely it's hard to. When they claim consent, unless there's like major injuries or something,
right?
It's hard to. But there are factors that you look at, and one of those would be, you know, prior conduct, other witnesses, how she was behaving. Part of the problem, to be honest with you, is a lot of times there's alcohol involved on both sides, and you know, it's a tough one. So
that's a hard one.
Yeah, it is.
But that is,
it is.
you know, and that's, I guess, the question I would have for David Leavitt is why the 50%?
Yeah.
And why?
Well,
why?
and I think
that would be one of my questions.
He doesn't really even claim that it's because there's no evidence. He doesn't want to ruin somebody's life because they have a criminal charge. And to me, taking responsibility for what you do is the first step to reform. And when you don't charge them and let them get off, the chances of them reforming are slim.
Yeah, they're minimal.
Hey, Jeff.
Yeah.
Yes.
Adam Bartholomew. I went to one of your town halls.
Yes.
I was just sitting there talking to David Leavitt, and he had said to a group of us that you've been sitting in the cubicle for 24 years, basically bolstering up the police cases. And I just wanted to get a word from you. I know you've been to the Supreme Court with cases and things like that.
You spoke to David Leavitt personally?
Yeah, just a few minutes ago.
He's here?
Yeah, he was here.
He stayed down.
So I just want to hear about your experience and your qualifications for this job before my battery dies.
Okay. All right. I haven't been in a cubicle for, as you say, I haven't been in a cubicle for 24 years. I've actually been to the Supreme Court as well, so I get out of it every once in a while. But I understand the Fourth Amendment really better than probably anybody in the state. I've been doing this for, it's my specialty. And he talks about me bolstering law enforcement. Let me give you an example of the Brigham City case. In Brigham City, that was in 2006, one of the cases I took to the Supreme Court. Officers saw a fight in progress inside a home, and actually a punch being thrown, hit somebody in the jaw, they're spitting blood. Police opened the screen door, shouted in police, nobody heard a word, they entered and broke up the fight. The Utah Supreme Court said that police couldn't do that because they didn't knock and they didn't have a warrant, all right, which virtually handcuffed law enforcement's ability to intervene in domestic violence situations. So we took that case to the U.S.
Were they called?
What's that?
Were they called?
Yes.
Were the police called by someone in the home?
Not in the home, outside the home.
Oh, okay.
Okay, so police, so we took it to the U.S. Supreme Court. The U.S. Supreme Court reversed the Utah Supreme Court in a unanimous decision, 9-0. All right, they said police can enter a home when they encounter that kind of violence inside the home. All right, that established the standard for this entire nation. We want police to intervene in those situations. That's not bolstering the police. That is protecting citizens and creating reasonable rules for police to go by. And as far as bolstering the police, I train police on a regular basis what they can and cannot do under the law. That's what I do. He hasn't done it once.
When do you do that?
What's that?
When do you do that?
I do that, like with Sandy City, they ask me every year on a regular basis. And I've done it for others. They've been my most regular. Yeah, because I'm from the attorney. I'll do it anywhere. I'll provide that training anywhere if I'm asked. If in Utah County, I will do that on a regular basis with our police officers. I will do it, and I'll do it, quite frankly, whether I win or lose, I'll do that. Because police need to understand the law. But we need a county attorney that just doesn't bash law enforcement, who doesn't really understand what they're going through. We need a county attorney that actually trains law enforcement to make sure that they do what they're supposed to do. That's in my interest, that's in the public's interest. That doesn't, if they do something that they're not supposed to do, then we have a bad case. I don't want that. Yet he hasn't done any of it. Now, he talked about misconduct claims. If there's a misconduct claim, I'm going to look at it. I will charge what the evidence supports. And if the evidence supports charges against a police officer, I will charge that. But he drags his feet. I mean, we had a case, 11 months, that he had this case on an officer misconduct claim and then decided to send it to Summit County. We can do these misconduct cases in most cases, we can conclude the investigation within 3 months. Police or the task force that's charged with that, they can do that within 3 months, and we will make a decision within a month. Okay, that's better for everybody. That's better for the officer, okay, because he's left in the lurch. It's better for the alleged victim because they're in the lurch for forever, and it's better for the public because they'll know that we're not sweeping it under the rug.
Cool. Thank you very much.
Thank you.
Best of luck. You got all the signatures?
No. Leavitt left everybody with that impression because he wanted to get the anti.
Oh, really?
Yes.
Oh.
Yes. Yeah, he wanted to get all.
There is a lot of anti-signature sentiment out there.
Yeah, and we always knew that it was going to be. We collected signatures, and we knew that it was going to be